Yes,
I'd like to mention for listing a drive for suspension of sentence.
you have filed your I
2024 matter.
huh?
2024 matter.
24 material will be listed. Give, give some date. Yes.
It was last listed on 10/1/2025. DP of Lilo.
IA?
For releasing of the bail. Bail. Get to bail.
Please, Your Lordship. Victim item number 8, my lord. On behalf of SMH, these are out of station, my lord. Kindly adjourn this matter. This subject leaves, my lord. Any day, please.
Lordship is a matter related to POCSO, no one is appointed for the victim.
Okay. It was by registered post. Earlier, notice was sent by registered post. Called Mr.
AK Das, my lord. AK Das, my lord.
A.K. Raslan, for that. SP William. And it's Silicon Rachel from Silicon Respond number 1 from State of Assam. This appeal is against judgment and order of conviction and sentence. Under the protection of children from sexual offenses Act of 2012. Also, notice was directed to be issued to the respond number 2 by registered post with AD. Put a hide order, hide order. Twenty-two 02/2020. As none have appeared for the respond number 2. As informed from us. We deem it proper.
Sure, I'm sorry to put it. Here, so R2 is the uncle.
Informant. Informant. Deem it proper. In the interest of justice, we appoint a legal aid counsel from the panel PANEL. Murder. Legal aid counsel to defendant That's one number two, that's. Or informal. This case, as sort for. The first, register to furnish a copy of the paper. Renewed from as sort for by, paid for by Mr. Swain to land after paying for the. These the case of the checks.
Yes.
Lordship, I beg to mention item number 11, Lordship.
Yes,
I'm praying for an adjournment for the day, Lordship, and if possible, can it be taken up on 5th of June, Lordship?
I will just adjourn for a day. Prepare this piece from your legal counsel.
Yes, Lord.
Amicus,
Legally.
legal counsel. This is possible for the day. They will extend adjourn for the day. Which this piece shall be in.
Okay.
Should I like to mention for listing of an I?
Why for what?
I put a bail application, the accused.
Should not-
Lordship, with the consent of the other side, Lordship, I have already submitted an adjournment slip. Lordship.
Item number,
Item 6 and 7, Lordship.
Mr.
N. Kolita, Lordship.
M. Colita
N.
and Colita Learned Council. Preparing for the.
N. Michael.
MSU, AMIC. Hearing. For the appellants. As we prepare for adjournment of the appeals. Councilman, HMO. Has also, great effect has also been circulated yesterday. Yes, we mean like, senior council in addition. For the rest of the state. Spread it. Something that. Guys don't take it from that stage to prepare for it. How much time?
Lordship, 2 weeks, Lordship.
What's the matter 2019?
7 years, very much. Oh, you are there, you are ready. 2019 matter, 7 years it is showing. It will be listed on some other, list the cases. If it's on. Yes, Mr. Chaudhary.
Public.
Yes. Two on one. We'll take up first part two, part appeals. We'll continue.
So, for item number one, my lord, one is the report has not yet come, my lord. But juvenile did, my lord.
So if it requires short time or long time?
Short time, my lord.
Short time, then we'll pick up, otherwise we'll take up.
No, no, my
the
report has not
Juvenile
come.
report
Huh?
hasn't come. So
Item
reminder
number
has to
one.
be sent.
Item number one.
Official date is 17/5.
You have juvenility.
My lord.
Yes.
Already medical, my lord, already done, my lord. When the report is due.
They heard Mr. Ishar Story, the senior counsel, estate by Mr. E. R. Miller, counsel for the applicant, appellate. And Miss B. Buyan, senior counsel and addition for prosecutor for the respondent, state of Assam. And Miss B. Borman, learned counsel for the respondent number 2. As per official dated 17/5/2025, the juvenility report has not yet been received by the office from the Court of Annexation, Judge Durham. So, in view of the, let the case be placed again on so.
Date. Next, I am having the item, my lord, actually, in fact, 2, 3, and 4. I am for 3 and 4, my.
Hmm.
For bail it has come. Your worship is, whether it's part or not, your worship is.
We'll take up first
First part.
supplementary and
Thereafter,
we'll apply our mind.
my lord. You can accommodate me, my lord, if I am somewhere. Obliged to us.
What are the other 5 to be 5 to some?
Why only NCR?
It is not yet, sorry, sir. It has not yet been received, my lord.
Mr. N. Mahajan, but Mr. N. Mahajan and Council for the applicants, appellant,
There are three.
and Ms. Sri Begum, the taking public prosecutor for the respondent state. Full stop. The records from the trial court have not been received till date. Post of later press reminder be issued for the trial court record, raise the case after 3 weeks.
Right, valuable.
Yes, we are, yes, yesterday we had. We kept. Ah,
So there is a condition of, it was not executed.
it is not executed, it is gone.
He has, something like that.
We have to proceed legally only.
The last thing,
Yes, last scene, what last scene? Running.
at about 8:30, the trial had taken
We
place.
calculated 3.5 hours.
That may not be too long.
And where is the last scene?
Then it was a market area,
Where is the last scene? Basically, they have to go together.
Yes.
Dispute arose, dispute settled.
Right.
Thereafter, what is the evidence? To bring in the last scene theory.
Paragraph 47, the judgment, we'll see. The appreciation by the, yesterday, I have read the entire evidence for paragraph 47. It is apparent that there is no eyewitness about the commission of the murder, but PW3 saw that few moments ago, before the death of Dasaru, there was a quarrel between the accused Vijay Krishna and deceased Dasaru. Although the defense side has pointed out that no independent witness had seen the quarreling, and the statement of PW3 is not corroborated by any other witnesses so far as quarreling is concerned. Yet the defense side could not create any doubt about the evidence of quarreling between the accused Vijay Krishna and the deceased before the alleged murder. So here only quarreling has been proved, but whether the death was caused by these persons only, that was not proved. And then, my lord, in paragraph 53 and 54. Paragraph 53 and 54, if I may, my lord, point out. Here in the instant case, it is revealed from the evidence on record that at the time of alleged quarrel and murder, no any independent witness was present at the place of occurrence. The neighboring people living near the place of occurrence have deposed without any exaggeration that they did not see the commission of murder, but saw the dead body of the deceased. Then 54, my lord, but the quarrel between the accused Bijoy and the deceased was witnessed by PW3 before the death of the deceased Dasaru. From the evidence on record, it is apparent that PW3 is the solitary eyewitness to the quarrel between the accused and the deceased before the death of the accused. And PW3 himself says that the dispute was settled and they left the place of occurrence. But the solicitor,
Cause of suspicion.
yes. No, no, answer. But the solitary testimony of PW3 about the quarrel between the accused and the deceased does not make the prosecution story doubtful. The defense side could not prove any animosity between PW3 and the accused person. Then, my lord, paragraph 57. It is also pertinent to mention in the DW1, the elder brother of the accused Vijay Krishna had deposed when he was in duty. Once Samarutanti arrived there and called him. He told him that his brother Shri Vijay Tanti had sustained knife injury by someone. Then he went to the bungalow of the manager and asked to provide a vehicle as his brother was injured. Then then he took his brother to the police station and police told him to take his brother to the hospital for treatment. After the medical treatment of his brother, he went to Dunduma PS to lodge an FIR. At the time of lodging the FIR, police arrested him and his brother Vijay Tanti and Samaru Tanti and thereafter sent them to jail hazard. Police recorded his statement. He does not know anything how and who murdered the deceased of this case, and he is falsely implicated in this case. At the time of his arrest, Tunduma PS, he told the police that he was not involved in the offense, and it has been clearly told by the manager of the tea state, but police did not take any heed to it. He came out of the factory after 11 p.m. on the date of incident, and he met his brother Vijay Tanti on the way off factory in injured condition. His brother told him that Dasaru Tanti had inflicted knife injury to him. From this deposition, it is crystal clear that at the time of the alleged offense, the accused Vijay Krishna was present, and in the altercation, the accused Vijay too received injury. The evidence of PW3 about the quarrel is corroborated by DW1. Hence, the testimony of PW3 becomes reliable and authentic. And another question, my lord, would arise, my lord, whether, under what circumstances DW1 was allowed to adduce evidence? Because under section 315 CRPC, it should be on an application made by him. My lord,
Did you
Those-
see?
my lord, that
Did you see
I have not
uh,
seen. my lord.
when
I have not seen.
because both have said 313 that we reduce evidence, both
Yes.
accused say. Now, on whose application this DW, 3W were examined? Did you see it?
No.
See, then it is whether these witnesses are on behalf of DW1 or this appellate.
Hmm.
Find out. You want us to see.
Hmm.
You want us to see,
No. No, I have
to make
I have-
submission.
No,
So you make submission and we'll go through the case record. After his going out from his shop, he was there in his house for an hour.
Yes. So that
Then somebody, one with person, informed him,
Dil Bahadur.
Dil Bahadur. Dil Bahadur was,
Present.
appears to be a material witness
It's
because Dil Bahadur informed the mother of the deceased as well as PW3.
He only raised an.
But there is, he is not in the list of witnesses in the charge sheet, nor the prosecution decided during the course of the trial that let him be called also by making an application, because his name has emerged as a material witness. So that is not done. To fill up the gap, he would have been one more vital witness for the prosecution. See the charge sheet, he is not in the list of witnesses.
10. Lordship, 10.
Dilbaru is not there.
But from the, lordship, evidence given by DW, the motive part. Lordship, taken into account. Then,
Now, that is why I have asked Mr. Gupta to find out these witness, DW 1, 2, and 3, they have come and deposed on behalf of the other court. Right?
and
If the other co-accused, these witnesses are at the instance of the other co-accused, not at the instance of this. Then confession of an co-accused.
if it is proved. Does not. So, but from his statement, which is exhibited document.
There was
it
no
comes out.
injury proved. It is an oral statement. DW,
DW, yes,
that this appellant sustained injury.
Right.
That injury is not proved,
injury was not.
not proved.
Injury of the accused.
This
person.
appellant,
Yes. Not proved.
not proved. He said sustained injury.
My lord,
If they were arrested,
my lord.
if they were arrested in the police station itself, this person had sustained injury,
Lordship,
stab injury or dagger injury or knife injury, he should have been examined medically.
lordship, my
My
lord.
lord, the statement of DW two, he was with
Lordship.
DW one, and if Krishna, if my lord will examine his statement also.
Not there. Not there. That part that he sustained injury in a fight with the disease, that is also not there.
Was not proved.
Statement of DW two, my lord, he says that he was with Amit Krishna, DW one, on the date of the occurrence at 11:30, and they went out together, page 32.
I was told when I started practice in law, if this proverb is applicable, no use. মাথাত আছে খাতাত নাই। মাথাত আছে খাতাত নাই, it is of no use.
Lordship, in the inspection memo. Vijay Krishna, while he was arrested. A repair lacerated wound measuring 6 AM.
মাথাত আছে খাতাত।
Yes. Nothing happened.
I used to have done it. He was quite aware.
And it should have been proved, your lordship. Yes.
Yes.
Was,
Yes, that would have been an incrementing circumstance in a chain,
yes.
but that is not proved. We cannot take into consideration now at this stage.
Page 105 and 106. Statement of Amit Krishna.
Ah. The dilemma of the court is, however strong the suspicion may be,
Lordship, one, although it was not proved, exhibit 9. At first, we went to Dumduma PS and thereafter we went to
Page,
the
page.
hospital. Page 105.
this is 105.
That statement of the co-accused Amit Krishna. But it was not proved.
Look look into it. Why this has been exhibited?
It was exhibited, but
Exhibited.
yes, exhibit 9. That it was not proved.
And
That was
when he deposed as a DW, then prosecution had the occasion, opportunity to cross-examine him which in relation to his previous statement, whether that was put to him.
was proved.
Otherwise, no contradiction. Let us see, DW one
Anil Krishna, 30.
on it Krishna. Here's 30. No, madam.
Oh, Lordship,
The cross examination
yes,
is
on the
there.
next day of the incident, police recorded my statement, in exhibit 9, the statement given before police. I have not seen the occurrence being,
Which one?
page 31. Cross examination of DW one.
So specific statement,
Exhibit 9. he
this
makes
is to
a-
be contradicted.
Yes,
Now he is DW
yes.
one. He himself deposed. There is a previous statement. Right? As an accused. But accused statement, he wasn't accused.
He was an,
Then
no, section 30,
this is What?
completion given of the evidence segment.
Oh.
Taken into account.
This is not completion. 161 is in the police custody.
No,
In by,
no, section 30,
no, that is completion of.
statement given by a co-accused.
Ah,
Lordship may see I may be wrong, just a one minute. Section 30 of the evidence.
But when but one thing, Miss Bhuya,
My lord.
before going to
It's not-
30,
it's not a confession.
if he extricates himself
Yes,
and incriminates the
somebody
co-accused,
else,
then it is not enough. He has to incriminate himself also and to incriminate the co-accused. Then it will be that kind of the
Yes.
principles laid down
but it is has to be a confession,
has to be a confession.
confession. When more persons than one are being tried jointly for the same offense. And a confession made by one of such persons
Ah,
affecting himself.
ah,
And some other of such person is proved
affecting himself.
himself. And,
Me and
And-
he, we together.
oh, the or is not there, and so he has to, no matter. Lordship, I will complete. The court may take into consideration such confession as against such other person, as well as against a person who makes it.
Right? So first condition is, first
Yes.
condition is
Yes.
that he has to incriminate himself
Yes,
and incriminate the co-accused.
yes.
Then it will be admissible.
Okay.
Otherwise, I am not there, he is there.
He is there.
That ground he was acquitted, clear. By-
So by taking that plea, he has got himself acquitted. But he has implicated,
From the court, Vijay Krishna.
that cannot be,
You don't have-
so that part goes in his evidence. There is no evidence that this appellant has sustained injury.
Dil Bahadur, that
Plus, if it is 161 statement, you have exhibited the statement. But he has to be taken to that part of that statement to contradict.
yes. My lord.
Then
That was
President
okay.
Ayub would have been put against. Small things
Dil Bahadur,
carries,
very at this stage, Lordship will. You want mine?
he is already there.
There's a charge sheet, he was not cited as the witness, the charge sheet was.
Yes. Criminal appeals.
I say, my friends can be referred.
Ms. Begum, point out whatever I miss.
The judgment, you know, yesterday I have cited that I will.
On what point?
Circumstantial evidence, my lord. It's a constitutional bench judgment. My lord. Earlier, Vidichan was also a full bench. The one which I pointed out
What point?
on the circumstantial evidence. This elaborated further points, my lord.
This one?
Yes. My lord, the paragraph 30, clause 3. Discusses Vidichan also, my lord, and then further lays down 5 my lord,
It
principles.
says discuss this Sarda. or-
Yes, yes.
That's all. That's all.
Sarda
It has
is-
relied on Sarda only.
Yes.
Nothing
This
else.
is also full bench. my lord. So, clause
Yesterday I was, what is locus classicus.
I have forgotten, but this is your,
Supreme Court has said
Once
Sarda has attained locus classicus.
Hmm.
This has not attained.
Wajir Khan is also there,
Huh?
but inside a room. Four one. But the case of base of circumstantial evidence when no eyewitness is available. There is another principle now which must be kept in mind, that the principle is that when an incriminating circumstance is put to the accused, and the said accused either offers no explanation or offers an explanation which is found to be untrue, then the same becomes an additional link in the chain of circumstance to make it complete. In this case, as he have told Lordship that I will depose TW, and that went against him.
This could have been in case of a sole accused. It could have been applicable in case of a sole accused. Here, it's an allegation in the 30234. In case of sole accused, perhaps.
This criminal appeal under section from jail under section Code of Criminal is directed against the judgment. An order dated 20/11/2019 passed by the Court of Learned Additional Sessions as to within bracket FTC, comma 3 case 50 in sessions case number 103 within bracket T of 2012. Closed up. By the judgment and order dated 20/11/2019, comma, the appellant has been convicted for the offense of murder under section 302, Indian Penal Code IPC. And he has been sentenced to undergo life imprisonment and to pay a fine of rupees 5,000, in default of payment of fine, to undergo a rigorous imprisonment for another year. Full stop. It has been provided that the period of detention already undergone by the appellant shall be set off against the sentence of imprisonment under section 428, CRPC. Fair. The prosecution case is that on 9/8/2009, a first information report was lodged by the informant, Sujo Mohan Kati, in bracket PW3, before the officer in charge, Dumduma Police Station. Post of in the affair, the informant PW3 and inter alia alleged that at about 10:30 PM on 8/8/2009, the four accused persons, namely one, Sri Vijay Krishna, two, Vishal Krishna, Vijay Krishna in bracket and referred to as the appellant, or A1, bracket close, 2, Vishal Krishna, 3, Monip Krishna, and 4, Pinku Krishna, who were brothers, got engaged in an altercation with Tasaru Tati, a resident of Malpua Tea Estate, Nagar Bosti, and uh, full stop. The disease, Tasaru Tati was the elder brother of the informant's wife. Full stop. According to the informant, the altercation arose due to a domestic matter. Full stop. In the altercation which occurred at line number 15, the accused persons assaulted Tasaru Tati and caused previous injury on his head and face. Full stop. As a result, Tasaru Tati died on the spot. Full stop. The informant, PWC, further released that the mother of the disease, Paikon Tati, was also assaulted along with him. Full stop. Whereas on receipt of the FIR, the officer in charge, Tumba Police Station, registered the same as Tumba Police Station case number 303/2009 for under section 302 IPC, grade with section 34 IPC, and initiated and trusted the investigation to one Babu Singh, Sub-Inspector of Police attached to Dumba Police Station, in brackets PW, to investigate the case. First. During the course of investigation, Commander IO PW10 arrested three of the four accused persons. And after arrest, they were forwarded to the court. However, the IO could not arrest the fourth accused person, Agent Pinku Tati, alias Pink. In the course of investigation, the IO visited the place of offense at Manpua Estate, 15 number line, and recorded the statements of the witnesses under section 161 CIPC. The IO prepared a sketch map of the place of offense PU EXC7. Thereafter, and also conducted inquest proceeding through an executive magistrate who, after inquest, submitted an inquest report within bracket EXT2. The postmortem examination on the dead body of the deceased was performed at Tinsukia Civil Hospital on 9/8/2009. After completing investigation into the case, comma, the Ayog submitted a charge sheet under section 1732 CRPC, right, charge sheet number 254 on 3/30/11/2009, finding in prime facie is against the four accused persons, comma, named in the upper for committing an offense, committing the offense under section 302 IPC rate which 34 IPC. In the charge sheet, comma, the Ayog mentioned that despite efforts, comma, the accused, comma, Pinku alias Tinku, could not be arrested as an absconder, comma, sorry, the Ayog made a prayer to declare thus the accused, to declare the accused, comma, Pinku as an absconder. Close. On submission of search in connection to a police station case number 303/2009, green bracket corresponding DR case number 1038/2009, before the Court of Learning Judicial Magistrate, first class Institute, comma, the learning judicial magistrate, first instance, secured the appearance of the two accused persons, comma, namely, comma, Punit Krishna, Vijay Krishna, we make it applicant, comma, A1, and Punit Krishna, A3. After issuance of process, full stop. The court, the Narayan court, as issuance, as proclamation, as an order of proclamation, an attachment was issued. Attachment and arrests was issued against the accused, comma, Pinku Krishna alias Tinku. The inquiry officer was examined. Full stop. And after examination, the inquiry officer, comma, the learning court declared the accused, comma, Pinku Krishna alias Tinku as an absconder. Full stop. As the copies were ready, comma, copies were furnished to the attending accused persons, A1 and A3, under, as part of provisions, section 207 CRPC. As the offense under section 302 IPC is exclusively tribal by the Court of Session, comma, the judicial magistrates, first class institute committed the case records of GR case number 103/2009 to the Court of Sessions by an order of commitment dated 45/2020. Full stop. The learning edition, public prosecutor was notified accordingly. On the receipt of a case reference of their case number so and so by the Court of Sessions. Comma. The case was registered as Sessions case number 410 3 Union Bracket T stroke 2000 by the Court of Sessions. Thereafter, comma, the case was transferred to the Court of Additional Session Judge FTC. Now, additional session judge. There's two FTC in Shukir for trial and disposal. We put in bracket because the trial court first one. First of, on the appearance of the accused, two accused persons. Vijay Krishna, 1, and Monique Krishna, 3, 8. The case was opened by the public prosecutor, the Court of Sessions. After hearing the public prosecutor and the defense counsel and perusal of the materials for the court of trial court proceeded to frame the following charges against the two accused persons. Page 6. The charge was thereafter explained and read over to the accused persons. The accused persons pleaded not guilty and claimed to be tried. During the course of the trial, the prosecution side examined 11 prosecution witnesses and exhibited 9 number of documents to bring up the charges against the accused persons. After closure of evidence from the prosecution side, the two accused persons, A1 and A3, were examined under section 313 CRPC by putting before them the incriminating evidence appearing from the testimony of the prosecution witnesses. When the accused persons were asked as to whether up to the purpose of the plea of the case of the accused persons was denial. And falsity of the prosecution case, when asked, both the accused persons stated that they would adduce evidence in their defense. Yes, that what whose instance?
I could not find what, from the report, it is not, there is no application as such.
During purpose of the defense side, reduced evidence of 3 defense witnesses. The details of the prosecution witnesses, exhibits, and detailed witnesses are given below. Thank you. After appreciation. After hearing the learning council for both the sides and after the evaluation of the evidence on record, the learning trial court proceeded to deliver the judgment in order dated so. Also, the learning trial court. Who are commitment on, commitment on. Commitment on. Amen. The case of the used from a Vishal Krishna was split up as he was found to be juvenile. The Karnataka trial court find sufficient evidence against the accused from a Moni Krishna entry to hold him guilty for the offense of murder with the aid of section 34 IPC. The learned trial court has however found that the appellant, the evidence against the appellant were sufficient to return the find of guilt for committing the offense of murder of Dasaru Tati. Holding him guilty, the appellant has been sentenced in a manner not mentioned. We have heard Mr. H. Gupta, learned amicus brief for the appellant, and Ms. B. Mia, learned senior counsel and additional public prosecutor, along with Ms. A. Begum, learned additional public prosecutor for the respondent state. There are Mr. Gupta, learned amicus brief for the appellant, has submitted that there was no eyewitness to the alleged incident of assault, if any, which led to the death of the deceased. The prosecution sought to establish the case of the appellant by way of circumstantial evidence. Most of it is contention that the chain of circumstances was incomplete. He has further submitted that the learned trial court had erred to base the conviction on the basis of last seen together theory. Full stop. The learned trial court has also wrongly relied upon a an event of quarrel which had allegedly took place between the appellant and the deceased at a point prior to the date of the deceased goes down. The disease was found lying dead on a public road on the date of the incident, and none from the neighborhood had deposed as regards the incident. Posted. The prosecution side had also failed to examine one material witness, who stated to have informed about the disease lying dead on the road to PW2 and PW3. It is his contention that the prosecution side has failed to lead cogent and reliable evidence in respect of each of the on each one of the circumstances to lead to form the chain of circumstances to draw an irresistible conclusion that it was only the accused and none other who was the perpetrator of the crime. Para. Au contraire, it has been submitted on behalf of the state that the trial court was right to hold that the appellant and the deceased were last seen together when a quarrel broke out between them. Full stop. It is contended that the circumstantial evidence and last seen together theory have been proved to indicate that none other than the appellant had committed the alleged murder or crime. Full stop. a reference has also been made to the evidence of DW one to contend that the applicant has sustained an injury on the date of the incident. And from the testimony of DW one, it had emerged that there was a fight between the appellant and the deceased on the date of the incident. Was supporting the findings accorded by the learned trial. In its judgment and order of conviction and sentence. The learned public prosecutor has submitted that no interference is called for. We have duly considered the submissions of the learned parties and have gone through the materials on materials available in the case records of sessions, case number 103, which bracket T stroke 2012, involving postal. As mentioned above, the prosecution side, in order to bring up the charge against the two accused persons, against the trial, I examined eleven number of prosecution witnesses. PW two was the mother of the deceased person. In her evidence in chief, examination from her PW stated that she knew all the four accused persons. Also, as regards the incident, PW stated that all the four accused persons had together killed her son when he was returning home after completing his duty. At that time, she was at her house. The incident was informed to her. Sorry. When a person named Dil Bahadur raised alarm in the street, she came out of her house. When she asked Dil Bahadur, Dil Bahadur replied that Mela. Could you make it a one? What? Yes, Mela. Over. Vishal Krishna Ilyas Bone, BUM, Moni Krishna Ilyas, Tinku Krishna to Tinku Asego, Mela, Bone, Monit, and Tinku together killed the deceased. Then PW went to the place of offense, saw her son lying on the road with injury on his head and back. Post of PW stated that subsequently Kawasi became unconscious. Post of when she regained consciousness after a few moments, she found herself at her house. Post of it was her son-in-law, PW3, who lodged the FIR at the police station in connection with the incident. PW2 further stated that prior to the incident, accused Tinku slapped her twice. And at that time, Tinku was armed with an axe. When she was examined by the court, PW stated that the wife and the daughter of the deceased were alive and they did not have any source of income. The age of the daughter of the deceased was 8 years and she did not go to school due to poor financial conditions. During cross-examination, PW2 stated that after the incident, she met Dil Bahadur in line number 15. Because of the place where Dil Bahadur told her about the incident was about 400 yards away from the place of offense. The houses of Dipali and Arjun were near their house, and there was no other house on that road. She denied a suggestion that she did not state before the police that Dil Bahadur raised alarm, saying that the 4 accused persons had assaulted her son with iron. PW2 further stated that at the time of the incident, she was cooking food in her house. PW3 in his examination stated that he knew both the appellant A1 and Anil Krishna A3. The deceased was his brother-in-law. As regards the incident, PW3 stated that on the date of occurrence, at about 8:30 p.m. on the date of occurrence, he was in his shop. At that time, a quarrel took place between the deceased and the appellant. At that time, the other accused persons, A4 and Vishal Krishna. A2 and A4 and one minor came to the place of occurrence and they asked PW3 to settle the dispute between them. PW3 stated that then he settled the dispute between the appellant, the deceased, and thereafter left the place after closing the shop. It was after few minutes, one person named Dil Bahadur Narsingh came to his residence to inform that the deceased was murdered And the dead body of the deceased was lying on Tinali, near the house of Bis Kishore Sah, it's very Facebook, and Asman Khati, put in bracket PW code. First one. On being so informed, he stated to have rushed to the place of occurrence, where the dead body was lying. First of going there, reaching there, he saw the dead body. First of. Then he had gone to the manager of the tea estate to inform him about the murder of the deceased. First of. The manager then told him to inform the matter to the police. Accordingly, he lost the FIR before at Dongdua police station. First of. He exhibited the FIR as EXT 6 and his signature therein as EXT 61. Full stop. He stated to have signed in the inquest report EXT 2 and identifies his signature therein as EXT 25. Full stop. PWT further stated that when the incident had occurred, A2, A1, A2, A4, and one minor were present. So, but the accused A3 was not present. He suspected that the above, the four persons named in the affair were, no, sorry, the above persons were responsible for killing the deceased. In his cross-examination, PW3 admitted that he did not see the assault caused by the accused persons. He further stated that his shop was situated about 15 to 20 feet away from Tinali, where the occurrence took place. He stated that before police, he stated that at the time of incident, he was at his house. First, prior to, in between the Tinali and his house, the houses of Benita and Ukia were there. First, he further stated that after quarrel with the appellant, it was after 1 hour of the quarrel, Dil Bahadur Narsingha informed him about the incident. He further stated that he had implicated the accused out of suspicion. PW4. Could you the two accused persons, A1 and A3, as well as the deceased, stated that he came to know about the date of the deceased from the people of line 15. only in the next morning. Close to. He heard that the accused persons, E1 and E3, along with others, caused the death of the deceased. Software. In his cross examination, PW stated that he only heard regarding the incident, but he not say exactly who informed him regarding the matter. Close stop. In his testimony, evidence in chief, PW defined who knew both the accused persons as well as the deceased, he goes to the effect that on the date of occurrence, his wife, Usha Tati, informed him over phone that the deceased was murdered by some persons. So it was only on the next day, he came to the place of occurrence and found blood stains on the road. So later, he came to know that the deceased was murdered by A1 and A3. During cross-examination, his PW5 stated that only after 2 or 3 days from the date of the incident, he could learn from the villagers that A1 and A3 caused the murder. PW6, Ukia Tati, PW6. Also knew all the accused persons, both the accused persons and the deceased. As regards the incident, PW6 stated that at about 8 p.m. on that day, she came out of her house, hearing human cry from the road. She saw the deceased lying dead on the road of line number 15. So later she heard that the accused persons had killed him. So she saw injury and blood on the head was released. So in Sapera, during cross-examination, PW6 stated that she came to know about the murder of the deceased when she was at home, and it was PW2 who informed her about it. So when she went to see the dead body, she went to see the dead body only after police personnel had arrived. So, at 10 a.m. She stated that she did not know how the murder took place. PW said, who also knew the accused persons and the deceased, deposed that it was about 10 p.m., the date of the incident, he came to know about the date of the deceased while returning from work. As asked by the manager, he informed the incident at the police station. Later on, he heard that the 4 accused persons, A1, had killed the deceased. It was after arrival of the police personnel, he went to see the dead body. Which was smeared with blood. Also during cross-examination, PW7 stated that he did not see the dead body, and it was in the morning, in the next morning, he heard that the four accused person had killed the deceased. He, however, expressed inability to remember the name from whom he heard about. He further stated that police did not examine it. Terror. BW 8, who also knew both the accused persons had a disease, stated that he did not know how the disease died was from. He further stated that though the police person came, they did not examine him. Close from. The cross examination of this witness, PW8 was declined by the defense. Para. PW9 was another co-villager from line number 15, who knew both the accused persons and the deceased. Close from. PW9 had stated in the examination that on the date of the incident, he was not at home. So he came to his residence only after 4 or 5 days on the date of the incident. And he came to know that a scuffle took place between the accused persons and the deceased, and for that reason, the accused persons committed the murder. During cross-examination, PW9 stated that he did not have any personal knowledge regarding the incident and police did not record his statement. Closed. Para. On from a look at the testing of the prosecution witnesses as PW2, PW3, PW4, PW5, PW6, PW7, PW8, and PW9. It is can be noticed that the prosecution witnesses, the testimony of the prosecution witnesses, PW4, are in the nature of hearsay evidence. In their testimony, these witnesses have stated that they can know about the death of the disease from others. Of the testimony of the house of PW6 was near the alleged place of occurrence. But she had stated that she did not know as to how the murder took place. PW7 came to know about the date of the disease after 10 p.m. PW9 came to know about the death of the disease only after 4 5 days from the date of the incident. PW5 came to know about the incident only on the next day. Both PW4 and PW5 stated that they came to know about the incident or death of the disease only on the next date of the incident. Full stop. Thus, the testimony of these witnesses do not go to add any weight to the prosecution case. We now turn to the testimony of PW1, who had performed the postmortem examination of the dead body of the deceased. In his examination, Chief PW1 stated that on 9/8/2009, he was working as sub-divisional medical and health officer at Tinsukia Civil Hospital. Full stop. On 9/8/2009, he performed postmortem examination of the dead body of the deceased in reference to Dundunga Police Station case number 303 for 2009. Full stop. The dead body was identified by a constable and one of his relatives, PW3. Full stop. On examination, he found uh, uh, 3 injuries. Page 9 of 1, 2, 3. On the dead body, on the person who had disease. Full stop. He further stated that other than the 3 injuries, he did not detect any other injuries. Full stop. In his opinion, recorded in the postmortem examination report, PW1 opined that the death was caused by as a result of head injuries sustained, and the approximate time since death was 18 days 24 hours. Full stop. PW1 further stated that number 1 injury was sufficient to cause death of a person in the ordinary course of nature. Full stop. He exhibited the postmortem examination report as EXT1, which is signature carried as EXT11. Full stop. Semicolon. The inquest report as EXT2, which is signatures therein as EXT21, 22, 3, 2, 4. Semicolon. The command certificate as EXT31, which is signature therein as EXT31, EXT3. The forwarding report as EXT4, which is signature therein as EXT41, and the dead body challan as EXT5, which is signature therein as EXT5. Subpanel. During his cross-examination, PW1 stated that the injuries mentioned in exhibit 1, postmortem exam PME report, were lacerated injuries. Full stop. He further stated that the injuries mentioned in EXT one, PME report might not be caused by falling or due to hit by any substance, as these injuries were always homicidal, neither accidental nor suicidal. Post of 89, the suggestion that the injuries could be sustained by falling or any other reason other than assault. Para. I hope the case was examined as speed of the case. For something is examination in chief command. He stated that on 18/2009, he received an information from the informant, PW3, PW7, and one Ajoy of Manopati Estate, line number 15, that the disease was killed by A1, A2, and A3. Post of. The officer in charge of Dumba police station endorsed him, entrusted the investigation to him, and he accordingly visited the place of occurrence at 12:45 midnight. Post. At the place of occurrence, he found the dead body of the deceased lying at Dinali of Machpur Estate, Manopati Estate, line number 15. He accordingly prepared his case memo of PO EXT7 and informed the magistrate to conduct inquest. The magistrate accordingly carried out the inquest and prepared an inquest report in by the EXT. On 9/8/2009, the informant, PW3, lodged the affair at the police station, and the same was accordingly registered. So the FI was executed as X6. After examining the informant at the police station, he again visited the PO and examined other witnesses, namely Srimati Okia Katia, is what benefit. Loton Katia. The clearly five. Rij Mohan Shah. The dead body was thereafter forwarded to Tinsukia Civil Hospital, Tinsukia, for postmortem examination. He forwarded PW to the court in Tinsukia for recording her statement under section 164 CRPC. The three accused persons, A1, A2, and A3, were arrested. But the other accused, A4, could not be arrested, and he was shown as an absconder in the charge. The accused, A2, was found to be a juvenile. After collecting the postmortem report, he completed his investigation and submitted the charge sheet. EXT 8 against the accused persons mentioned by here above. During cross-examination, PW 10 stated that he received the information regarding the incident at about 12 midnight on 8/8/2009. Post op. He did not submit the extract copy of the general diary entry regarding the information received about the incident. Post. He further stated that near the place of occurrence, the houses of PW 5, Vijay Mohan Kati, Asman Kati. Is a DW? Asman Kati. Asman Kati. Huh? DW? Okay, PW 4. Over situated. Close to. At the time of the alleged, he further stated that at the time of the alleged incident, all the said few witnesses were inside their houses and no one had witnessed the incident. He further stated that he did not send PW 2 for her medical treatment. PW 3 stated before him that it was A4 who assaulted her son with an axe. And PW 2 did not name any other accused persons as assailants. He further stated that except the statements of witnesses, he did not find any other incriminating material regarding the presence of the accused at the place of occurrence. First off. In her statement recorded under section 164 CRPC, PW to confirm that it was A4 who had assaulted her son with an axe. Post op. He further stated that he did not find any weapon of assault and the PU. And he did not record a statement of Dil Bahadur Narsingha. Post op. Denied a suggestion that he had filed the charge sheet falsely against the accused persons from A1 to A4. Post op. He further clarified that the incident took place during the night hours and the place of occurrence was dark at that point. PW 11 was a judicial magistrate first class. Was serving as a judicial magistrate first class at Tulsikia on 14/8/2009. When he recorded the statement of PW 2 under section 164 CRPC. In his examination chief from PW 11 exhibited the said 16 statement recorded in the 160 CRPC of PW 2 as EXT 9, which is the signature there in EXT 9. First of cross-examination. The PW, the software PW 11 was cross-examined by the defense. Post op. Yes. It is exhibit 9, where is the page? Exhibit 9. So. PW. PW. 11. Exhibit the statement of. Exhibit the previous statement. Of PW. PW. 2. Recorded under. Section 160 CRPC, comma. The. Previous statement. As exhibit 9, comma. Exhibit 9. Was. Not shown. To. PW 2. When. During her testimony. In previous statements. Recorded under section 160 CRPC. Can be used both for both corroboration and contradiction. First. As regards the previous statement recorded under 164 CRPC is concerned, comma, it serves two purposes, comma, firstly, comma, to deter the witness from changing his stroke her stand by denying the contents of his stroke her previously recorded statement. Semicolon, and secondly, comma, tied over immunity from prosecution by the witness under section 160 CRPC. To stop a proposition to the effect that if a statement of a witness is recorded under section 164 CRPC, comma, is evidence in court should be discarded, comma, is not at all warranted. To stop. Section 160, 157 of the Evidence Act has provided that a statement recorded under section 160 CRPC can be relied upon for the purpose of corroborating the statements made by the witness and or to contradict the same. Post. As in the case in hand, comma, the defense had no fortune to cross-examine the witness, comma, PW two statements was recorded previously under section 164 CRPC by not exhibiting EXT 9 through PW 2, comma, such previous statements, that is EXT 9, cannot be treated as a piece of substantive evidence to bring any benefits to the case of the prosecution. Full stop. Para. The defense, sorry, the prosecution has sought to place a reliance in the testimony of DW1, that is A3, who entered into the witness books to raising the plea of alibi. First, to support the testimony of DW1, comma, DW2 and DW3 had also deduced evidence in support of DW1 post PS plea of alibi. First off, the Lorry trial court, after evaluation of the evidence of the prosecution witnesses and the defense witnesses, comma, appeared to have accepted the plea of alibi raised by DW1, comma, who faced the trial along with the appellant, first off, and acquitted A3 from the charge under section 302 IPC rate with section 34 IPC. First one. The piece of evidence to which piece of evidence of DW, the part of testimony of DW1, to which the prosecution had pointed is was about sustaining injuries by the appellant on the date of the incident. In his testimony, comma, DW1 deposed to the effect that when after 11 PM on the date of the incident, he came out from the factory. He met the appellant who was on his way to the factory, comma, in an injured condition. First off. When asked, comma, the appellant told DW1 that the disease had inflicted knife injury on the appellant. First. During cross-examination of DW1 by the prosecution, comma, the prosecution exhibited the statement of previous statement of DW1 recorded under section 161, CRPC. First of it has been argued that this part of the testimony of DW1 is an incrementing circumstance against the appellant. And is an additional link in the chain of circumstance. In view of section 30 of the Evidence Act. Full stop. Upon consideration of such submission, comma, such submission is found not acceptable. Full stop. Firstly, comma, a previous statement recorded under section 161 CRPC cannot be read into evidence in the trial of an accused, Full stop. The accused, comma, A3 was arrested immediately after the incident, and such statement according to section 161 CRPC. And the statement, comma, under section 161 CRPC, comma, EXC9 was recorded during the custody. Full stop. Secondly, comma, section 30 of the Evidence Act has prescribed that when more persons than one are being tried jointly for the same offense, and a confession made by one of such persons affecting himself and some other of such persons is proved, comma, the court may take into consideration such confession as against such other person, as well as against the person makes such confession. One, the most pertinent ground for accepting a confession of a co-accused is that the co-accused who had made the confession, comma, has to implicate himself and the other co-accused for the offense alleged. Full stop. If the co-accused does not incriminate himself and incriminates only his co-accused, then such confession cannot be accepted. Full stop. In the case in hand, comma, DW1 entered the witness box, raising the plea of alibi, comma, meaning thereby, comma, he had adduced evidence to extricate himself from the charge under section 302, IPC in with section 34, IPC. Full stop. He had adduced evidence he had adduced his evidence and the evidence of DW and DW3 to to advance his plea that he was never at the place of occurrence and was not with the appellant. In the alleged incident of assault on the the it was one. It was one. Dil Bahadur Narsingha, to whom the two prosecution witnesses from our PW2 and PW3 had attributed the role of informing them about the alleged incident of assault on the deceased. PW as stated above, PW2 stated that it was Dil Bahadur Narsingha who raised alarm on the street, and hearing his alarm, PW2 came out of her house, and when she asked Dil Bahadur Narsingha, Dil Bahadur Narsingha replied that it was the accused persons A1, A2, A3, and A4 who together had killed the deceased. PW3 stated that when he left for his house after closing his shop, Dil Bahadur Narsingha came to his house after a few minutes to inform that the deceased was murdered and the dead body of the deceased was lying continually. In his cross-examination, PW3 clarified that PW3 state that it was after 1 hour of the quarrel, Dil Bahadur Narsingha informed him about the incident. PW3 in his earlier part of the testimony, stated that the quarrel took place at about 8:30 p.m. The IO, PW10, had state that he did not record the statement of Dil Bahadur Nursing Home. From the testimony of PW2 and PW3, if the testimony of PW2 and PW3 on the above aspect are to be accepted, then nor Dil Bahadur nor Simha would emerge as a material witness. First of all, a material witness is one who would unfold the genesis of the incident or an essential part of the prosecution case. And by examining such material witness, the gaps or infirmities in the case of the prosecution could be supplied. First of all, if such a witness, it has been held in Takhazi Hiraji versus 2001 6 SCC 145, that to the effect that if such a witness, if such a material witness, without justification, is not examined, inference against the prosecution can be drawn by the court. In the absence as Dil Bahadur, Norsima was not examined as a prosecution witness. Now, Dil Bahadur Norsima, sorry, the statement of Dil Bahadur has emerged from the discussion about the statement of Dil Bahadur Simha was not recorded under section 161 CMS recorded by the IO during the during the investigation. Dil Bahadur Norsima was not cited as a witness in the charge sheet. Even during the trial, when the name of Dil Bahadur Norsima was mentioned by PW3 and PW2 and 3, the prosecution did not make any effort to call and examine Dil Bahadur Norsima as a witness. Thus, the testimony of PW2 and PW3 on the aspect of informing them about the alleged incidents is in the realm of hearsay. Even the factum of informing about the incident by Dil Bahadur Norsima to them is, it cannot be read into evidence. Para The prosecution side as well as the learned trial court had based its case on the Lassen theory. Also, evidently, in the case in hand, there was no eyewitness, and the case was based on circumstantial evidence. Also, the Lassen theory the Lassen theory can be invoked as a facet of circumstantial evidence. It may be a weak of evidence by itself, to find conviction on its own, first of, but when it is coupled with other circumstances, such as the time when the disease was last seen with the accused, and the recovery of the corpse being in close proximity of time, then the accused owes an explanation under section 106 of the Evidence Act with regard to the circumstances under which death may have taken place. First off, if the accused offers no explanation or furnishes a wrong explanation, absconds, motive is established and there is corroborative evidence available inter alia in the form of recovery or otherwise, forming a chain of circumstances leading to the only inference for guilt of the accused, comma, incompatible with any possible hypothesis of innocence, comma, conviction can be based on the same. If there be any doubt or break in the link of chain of circumstances, comma, the benefit of doubt must go to the accused. Custom. Each case is therefore have to be examined on its own facts for invocation of the doctrine of class injury. In bracket, Haryana, Satpal versus State of Haryana, 2018, 6 SSC, 610. Custom. Revert. The circumstances of last seen together can be brought into consideration for finding the accused guilty of the offense charged, which, when it is established by the prosecution that the time gap between the point of time when the accused and the deceased were found together alive and when the deceased was found dead is so small that possibility of any other person being with the deceased could be completely ruled out. First off, the time gap between the accused person seen in the company of the deceased and the detection of crime would be a material consideration for appreciation of the evidence and placing reliance on it as a circumstance against the accused. But reverting back to the facts of the case, comma, the PW3, sorry, the prosecution is, comma, PW3 testified to the fact that at about 8:30 p.m. on the date of the incident, comma, a quarrel took place between the appellant and the deceased. And at that time, comma, the other accused persons, comma, A2 and A4, I am not A4, comma A4, and one minor came there and they requested PW3 to settle the dispute between the accused, the appellant, and the deceased. Was the PW3 also testified that he then settled the dispute and left the place after closing the shop. First, the other than PW3, no other witness had lended corroboration on the issues of dispute and settlement. Full stop. The land trial court had only was only found to have harmed on the issue of quarrel. Full stop. There was no discussion on the point that after the quarrel arose, a settlement was also arrived at. Full stop. PW3 did not testify that after quarrel and settlement of the disputes, the appellant and the deceased left the place together. Full stop. In the absence of such evidence of leaving the place together, the last in theory cannot be automatically brought. Full stop. There has to be corroborative evidence that they were last seen together prior to discovery of dead body of the deceased. Full stop. According to PW3, the time gap was about 1 hour. Full stop. There's, however, time gap between leaving the place, no, time gap of the settlement of a dispute. The testimony was testimony PW3 about the time gap between the dispute settled and information received by him from Dil Bahadur so and so cannot be accepted in absence of other corroborative evidence, because the factor of giving information to PW3 by Dil Bahadur so and so has already been discarded by us. Okay. As per PW, the IO, PW10, it was at about 12 midnight on 8/8/2009, he received information from PW3 as regards the alleged incident of death of the deceased. Full stop. We find from on analysis of the above evidence, we find that the last seen of theory in the absence of any other piece of evidence cannot be accepted as the time gap was such that the involvement of any other person in the incident was solved. Cannot be ruled out. Person. As the last seen theory is not applicable, is found not applicable in the case, there is no necessity. The onus does not has not shifted to the appellate to provide an explanation regarding the dates, alleged, dates, regarding the alleged murder of the deceased. The the case is based on the case of the prosecution is based on circumstantial evidence. Full stop. Senate amicus curiae has referred to a decision in Abdul Nasser versus State of Kerala and another, 2025 SSC 9 SC 110. The as regards the principle of case, the case based on circumstances evidence, the decision in Sarda so and so has attained the status of locus classicus. Full stop. The law is well settled. Insurance and carrying the law is well settled that each and every incriminating circumstance must be clearly established by reliable and cleansing evidence. And the circumstances so proved must form a chain of events from which the only irresistible conclusion about the guilt of the accused can be safely drawn, and no other hypothesis against the guilt is possible. Full stop. In a case depending upon circumstantial evidence, there is always a danger that conjecture or suspicion may take the place of proof. Full stop. The court has to satisfy itself that various circumstances in the chain of events have been established clearly, and such completed chain of events must be such as to rule out a reasonable likelihood of the innocence of the accused. Full stop. It is subtle, it is a subtle proposition that when the important link goes, cuts off, important link cuts off, the chain of circumstances gets snapped, and the other circumstances cannot in any manner establish the guilt of the accused beyond all reasonable doubt. There is a long mental distance between quote unquote may be true and quote unquote must be true, and the same divides conjectures from such conclusions. First of paragraph. Having considered the entire evidence record, entire evidence, the prosecution side has brought on record, comma, we are not persuaded to hold that the prosecution side has been able to establish all the circumstances, all the events, the chain of circumstances by reliable and upholding and cleansing evidence. And thereby to form a complete chain of circumstances pointing unerringly that it was the appellant only and none other, comma, who had committed the alleged crime. First of, it is too settled that when two so and so hypotheses, then one must, which goes favor of the is to make sense. And fact situation obtained in that case, comma, to find that the prosecution side has failed to establish its case against the appellant. Yeah. The reason it was. As a result, from the present instant immediately succeeds by the appellant is therefore acquitted of the charge for murder under section 3 for my list. The release for custody and custody. And so. Okay, 357. Complete. The LCR percent, PCR percent, right? Okay. Anything else? Anything left? Your argument, anything left? Your answer, anything left? Oh. One more. I don't know, I cannot. Take up or otherwise we'll fix tomorrow. If time does not permit, fix tomorrow. Yes, then we'll pass the order. Let us see. In item number,
2, 3 and 4.
objections are filed everywhere.
Yes, yes.
Objections are filed.
Yes.
Let us see. 302.
Yes.
I do. Asmat Ali.
One compilation was given now.
Asmat Ali.
List of dates will be given.
IA.
Yes.
Madam, you have filed objection.
Yes, we,
Where? One consolidated objection or? Kind of,
Separate.
separate. Find out. Second song. Second, because you know, so immediately.
item number 2, my lord, not 5 because up to 7 years. 2 is 7 years.
Okay.
So over 2, 3 and 4 your lordship.
Okay. Would it be inconvenient if I post these cases from Friday? List already prepared, huh? Okay, then post it, heard Mr. H.R. Sotri, Learned Senior Counsel, assisted by Mr. Ayu Choudhury, Learned Counsel for the applicants, appellants, and Ms. A. Begum, Learned Additional Public Prosecutor for the opposing party, State of Assam. First of the Learned Counsel for the parties have submitted that in all the applications prepared and seeking suspension of execution of sentence, the objection has been, objections have been filed. Full stop. As agreed to by the Learned Counsel for the parties, release the cases on Friday. And it will come on the top of the list.
Obliged. 23.
Not that. Just have a look. No. What are the points you have argued yesterday? You doubted the testimony of
PW2 and 3.
PW two and three. Yes. Okay,
PW3 said, PW3 and 6, the father and son, they say they have been informed by the CW1.
PW three and
And
PW six.
They say,
PW
three.
six. Informant.
informed, that they have been informed by CW1
Yes.
about the incident. CW1,
And CW one denied saying
Denied
to PW three,
she doesn't say anything.
but not, no question
Hmm.
about PW six. And what is the status of a court witness? And CW1,
CW1 has filled up the,
let's just have a look. at
that she has
CW1.
taken PW2 and 3 to the court for
CW1,
conscious
right?
effort.
CW1.
CW1.
CW1, how many CW1? Is 24 is another CW1.
That should be CW2.
Who was examined first in point of time? 18/7. Okay, C should be CW2. Right?
Santa
Because-
Lumis was later.
So
2008.
C should be CW2. Okay.
CW1 has brought before the court the GDA.
PW2 stated that C was only, C, the accused and the appellant were present and nobody else. So CW,
two
PW2
in her
eh, chief,
testimony before the court,
in chief.
let us see one second.
1, 2, 8th line. from top. No other person was present near the place.
Where she said about harassment?
She says, she doesn't say about her husband.
Oh.
So C, the appellant and the victim, only these 3 persons. If these 3 persons were there, CW1 could not have been there. If we believe her.
So you doubted her testimony on the strength of 164 state,
164 is
where
there.
there is a different
but,
version.
That cannot be relied on.
Ah.
Otherwise, they have completely somersault themselves.
PW3 also has 164 statement.
Yes, yes, madam. He is exhibit 566 page.
There is a change. So you did not complete the part required under section 145 Evidence Act. So that cannot be considered as a contradiction. Please speak your seat. Any other point?
No one.
Assail is which? In this criminal appeal from jail under section 3 command of criminal procedure. To a judgment. And order dated 2/5/2018. Passed by the Learned Court of Sessions. Passed by the Learned Sessions Judge. Hibahara. In Sessions case number is 35 on state, 279 in bracket. As that C of 2015, which arose out of ZR case number 70/2015 and Punari Police Station case number 176 of 2015. By the judgment and order dated 2/5/2018, the accused appellant has been convicted for the offense under section 302, Indian Penal Code. And he has been sentenced to under rigorous imprisonment for life and to pay a fine of rupees 1,000, in default of payment of fine, to undergo simple imprisonment for another month. Para. The first information report FIR was lodged before the officer in charge of Bhoypur Police Outpost on 2/9/2015 by one Kalidas Pumij, within bracket, informant the speed of 6, stating inter alia that at about 3:30 PM on 2/9/2015, when his younger brother, Mokul Pumis, zero, 09/2015, had gone to bring back the cattle from the paddy field in front of his house, his neighbor, Nitai Pumis, within bracket, accused the fellow, killed him brutally by hacking with a naga dao in the neck as well as in different parts of the person of Bokul Pumis. Post of Para. On receipt of the FIR, the in charge Safri SFRY Police Outpost registered a general diary entry, ZD entry number 290 stroke 2015, dated 20/09/2015 at 8 PM, and forwarded the FIR to the officer in charge, Punari Police Station for registering the case under proper sections of law, while taking up the investigation of the case in the meantime. Post on. On receipt of the FIR, the officer in charge, Punari Police Station, registered the FIR as Punari Police Station case number 176 of 2015 for the offense under section 302 IPC on 20/09/2015. Also. Para. During the course of investigation, the IO, PW9, visited the place of occurrence, which was at the village Rongpothar. Sorry. Rongpothar Gaon. After registering the channel diary. It has emerged. Sorry. It was at 4 p.m. on 20/09/2015. Comma, the IO 11 B2 Bhumij bracket PW3 came to the police outpost and verbally informed the in charge Safri police outpost within bracket PW9 that the accused appellant had killed his uncle, Mukul Bhumis, Kuchedao, Pustak. The same information was entered as in the general diary as Safri Outpost General Diary entry number 287, dated 20/09/2015. Post office. PW9 had thereafter visited the place of occurrence at Rangpathar Gaon. Post office. At Rangpathar Gaon, there were 3 hillocks. And as per the testimony of IO, induced as PW9, he saw the accused appellant sitting in one hillock, which down to stop. The accused was apprehended and the Dow was seized from his position to provide EXT 3 list. Full stop. Thereafter, the dead body of the deceased, Bakul Bhumij was recovered from the paddy field on the other hillock with the help of others. Full stop. Inquest proceedings on the dead body of the deceased was performed and an inquest report in bracket EXT 4 was prepared. First of all, a sketch map of the place of occurrence PO was prepared by EXT 6. First of all, thereafter, the dead body of the deceased was brought to the police station. First of all, para. It was at about 6 p.m. on the same day, that is, on 20/09/2015, the informant lodged the FIR stating and alleging the facts already mentioned. Full stop. On receipt of the FIR, general diary entry number 390 was made by the Safri outpost, in charge, Safri outpost, and the FIR EXT 5 was forwarded to the officer in charge, Pune outpost, whereupon the case, Pune police station case number 176/2015 was registered. Full stop. Para. The postmortem examination, the dead body of the deceased was performed at Hibagagar Police Civil Hospital on 21/9/2015. In reference to Safri Outpost ZT entry number 287 stroke 2015, dated 20/09/2015. Post. After conclusion of after completing the investigation. Oh, sorry. In the course of investigation, the IO, PW 9 also forwarded two witnesses, PW 2 and PW 3 to the court of learned Judicial Magistrate First Class Sorailio for recording their statements under section 164, CRPC. And their statements were recorded under section 164 CRPC by the learned Judicial Magistrate First Class Sorailio, within brackets. Examine, Judicial Magistrate examine. On where are those?
At 58 and 66.
58 and
66.
66.
Can we-
On 24/9/2015. Post. After completing investigation into the case, the IOPW 9 submitted a charge sheet under section 163 CRPC, a wide fire sheet number 142/2015, within brackets, EXT 7 on 37/2015, finding a prima facie case for the offense under section 302 IPC against the accused appellant hearing. Full stop. Para. As the accused appellant was in jail custody, his appearance before the learned committal court was secured on 10/12/2015 from jail custody. Post op. As the copies were ready, the same were furnished to the accused appellants as per the provisions of section 207, CRPC. Post op. As the search sheet has been submitted for the charge under section 302 IPC, which is exclusively tribal by the Court of Session, the learned committal court void an order of commitment dated 10/12/2015. Committed the case records of GRTS number 702/2015 to the Court of Sessions, Hibag, by notifying the public prosecutor and by fixing the date before the learned Court of Sessions on 23/12/2015. With a further direction to produce the accused appellant before the Court of Sessions on the same date. Para. On receipt of the case records of hearing case number so and so, comma, the learned court of sessions registered the same as sessions case number 279, bracket SC of 2018. The case was opened by the case of the prosecution was opened by the learned public prosecutor. After hearing the learned counsel, learned public prosecutor and the learned defense counsel and upon perusal of the materials on record, command the learned court of sessions within bracket the trial court proceeded to frame the following charge against the accused. After framing the charge, the charge was read over and explained to the accused, to which he pleaded not guilty and came to be tried. Person. During the course of the trial, the prosecution examined nine witnesses and exhibited a number of documents to bring home the charge of murder against the appellant. Gustav. In addition, two witnesses were examined as court witnesses, CW1 and CW2. Gustav. Already, after conclusion of trial, after closure of evidence from the prosecution side, the accused was examined under section 313 CRPC. First of the plea of the accused in reply to the incriminating circumstances put before him, appearing from the testimony of the prosecution witnesses, was having no knowledge. First of, he pleaded falsity in the prosecution case. First of, when asked, he declined to adduce any defense, So, however, he put forward an explanation when he was asked whether he had anything more to say in that case. After hearing the learned counsel for the parties and after evaluation of the evidence report, commander trial court proceeded to deliver the verdict of guilt against the appellant in the apostolic manner. I have heard Mr.
After the
Deepa
court witnesses were examined, he was again given a chance under 313.
তার আগত 313 হৈ যোৱাৰ পিছত the court invoking the provisions of section 311 CRPC examined two witnesses as court witnesses from a C1, CW1 and CW2 thereafter. Also, after examination of the court witnesses, The court witnesses were also permitted to be examined by both the prosecution side and the defense side. Yes. Thereafter, the accused was again examined under section 313 CRS. Option evaluation. Huh? Huh? We have heard Mr. B. Prasad learned amicus curiae for the appellant and Miss A. Begum and additional public prosecutor for the respondent state. Mr. Prasad learned amicus appearing for the appellant has submitted that the prosecution witnesses, the testimony of the prosecution witnesses, PW2 and PW3 cannot be accepted.
Let it be only PW two, particularly PW.
PW2. Prosecution witness, PW2 cannot be accepted. Could not have been accepted as our evidence regarding witnessing the act of assault that exists was doubtful. Mr. Prasad has submitted that as per the testimony of PW2, she was in the backside of her residence at the time of the alleged incident. If PW3 was in the backside of her residence, then if the said piece of evidence is compared with the sketch map bracket EXT6, then it is difficult. It will be difficult to accept the veracity of that part of the testimony of PW2 without any further corroboration. He has further submitted that the statements of the prosecution witnesses, PW2 and PW3, were recorded under section 164 CRPC. And in their previous statements, PW2 and PW3 had given a completely different version, which is at variance with their testimony before the court. First, Mr. Prasad has further submitted that the PW3 had a cause of animosity with the appellant and had a motive. As it has emerged from the evidence on record, and as the appellant had explained in his reply during his examination of 313. First, he has further submitted that the testimony of PW 3 cannot be accepted as of the testimony of CW 1 as CW 1 testified that she did not tell the incident to PW 3 at any point of time.
Was in chief, otherwise in chief, he said I was not at the place. PW3 was not at the place, so he doesn't know anything. Whoever-
He was told by PW,
He- that's what
CW 1.
he said. CW, that was-
On amicus curiae, as Commanders contended that the conviction of the appellant is not sustainable on the basis of the solitary eyewitness. That is PW 2. When her testimony of witnessing the incident itself is doubtful. There are no other cleansing corroborative evidence to sustain the conviction. Yes, Bhagam, the additional public prosecutor appearing for the state has contended that the depth of the disease was clearly a homicidal one, as the disease had sustained a number of grievous injuries on his person. First of all, the testimony of PW2 cannot be termed as a doubtful one, as her presence in her own house at the relevant point of time was natural. Full stop. From the sketch map, ext so and so, as well as from the evidence on record, it would emerge that the area was a secluded one. Area did not have, was it not a populated one? With only two houses nearby. That is the houses of the appellant
And they,
and the house of the deceased, PW3 and PW2, PW20. The wife of the appellant was also examined as CW1 and in her testimony, CW1 had deposed about witnessing the incident of assault on the deceased by her husband.
My lord, at page 43, paragraph 22, in the judgment.
Ah.
CW1 ought to have been numbered as CW2.
লিখব CW2 ব্র্যাকেটত লিখিব আৰু incorrectly numbered as CW1. By pointing to the evidence on record and its additional public prosecutors that no interference is called for as the land trial court had appreciated and evaluated the evidence in the right perspective. We have duly considered the submissions of the land council for the parties and have also gone through the materials on record available in the case record of session case number so and so in original, including the testimony of the prosecution witnesses, court witnesses, and the documentary evidence. Those para. Before turning to the evidence of other prosecution cases, is it appears apt to refer to the medical evidence at first. It was PW1, who was working as medical and health officer as one at Sibsagar Civil Hospital on 21/9/2015, who performed the postmortem examination on that day on the dead body of the deceased, Gokul Punis, on police requisition and in reference to Sapri Outpost CBNT number 27/2015. Full stop. The dead body of the deceased was identified by PW Sheikh and one Mongol Punis. On in his evidence in his examination sheet, PW1 stated that on examination, he found the following injuries. He found a number of injuries on the person of the deceased. First of and the same injuries, whereas under base 9. That's good. Yes. He, PW1, exhibited the postmortem examination report as EXT1. He also identified his signature in EXT1 as EXT11 and the counter signature of the Joint Director of Health Services as EXT12. in his opinion, in EXT one, EXT one PME report, PW1 opined that the cause of death of the disease was due to, as a result of severe injury. PW1 further testified to the effect that the injury number Roman 1, Roman 2, Roman 3, Roman 5 were sufficient to cause death of a person in the ordinary course of nature. He further stated that those injuries might be caused by using sharp cutting weapon like dao. PW1 was cross-examined by the defense. In his cross-examination, PW1 stated that he did not mention in EXT1 about the age of the injuries. He further stated that the LS occurrence took place, as could be seen from the requisition. Later, the LS occurrence took place on 20/09/2000. There is no, from the nature of injuries and from the testimony of PW, the autopsy doctor, PW1, and the post-mortem examination report, EXT1, it is clearly demonstrated that it can be clearly noticed that the date of the disease was a homicidal one. The injury, the whole number of injuries, as stated above, were found to be sufficient to cause death in the ordinary course of nature. From the nature of injuries, the autopsy doctor had opined that the injuries might be caused by using a sharp cutting weapon like dao. Before turning to the testimony of the witnesses, who were termed as vital ones by both the prosecution and the defense, we testimony of the other witnesses are required to be analyzed for finding out their probability value. PW7, who was a police constable, had merely escorted the prosecution witnesses, PW2 and PW3 to the court on 24/09/2015. For recording their statements. He only knew that the statements of PW2 and PW3 were recorded in court. Full stop. PW4 PW five and PW five were co-villagers being residents of Rongpotar Gaon. So they knew both the appellant and the deceased. Full stop. PW four stated in his evidence in chief that on 20/09/2015, police person came to the village and requested them to pull out the dead body from water in the paddy field. First of, as per PW four, PW three and PW five were also with him at the time, and the appellant was with the police person. First of, PW four stated that he pulled out the dead body from water. First of, PW five was another person who, along with PW four and PW three, PW four, pulled out the dead body from the water in the paddy field. First of, PW four was a signatory to the seizure list from a EXT three. What is EXT three?
Sixty,
Huh? Okay.
60.
EXT three and EXT four, inquest report. Postal. Similarly, PFW five was also a signatory to the seizure list, EXT three seizure list and EXT four, inquest report. Postal. Though PW three four, while PW four stated that he had no knowledge about the seizure of any DAO of appellant by EXT three seizure list, one Naga DAO of about 2 feet, including the handle, was shown to have been seized by the IO on being produced by the appellant at 5 p.m. on 20/09/2015 at village Rongpotar. Full stop. In his testimony, PW stated that he did not have any knowledge about the seizure of any DAO. Full stop. On the other hand, PW five deposed to the effect that the appellant had handed over one DAO to the police personnel, and the police personnel seized the DAO from the appellant. Full stop. PW five also identified the seized DAO as MAT EXT one. Post up. Denied your suggestion, P5 denied your suggestion. The appellant did not hand over the dog to police in the field. First. From the testimony of PW4 and PW5 command, it is evident that the dead body was pulled out from water in the paddy field on 20/09/2015 itself. First. A dog of about 2 feet length, including handle, was also seized on 20/09/2015. First.
PW8 has also made similar statement like PW4 and 5.
PW.
Please continue.
PW8, comma, another co-villager, comma, corroborated the testimony of PW4 and 5, PW5, on the point that on 20/09/2015, comma, police personnel came to the village and requested them to help in recovering the dead body of the deceased from the paddy field. Post up. PW8 also stated, further stated that the PW4 and PW5 were with the police personnel at the paddy field. Post up. PW8 further stated that after pulling out the dead body from water in the paddy field, comma, it was put in a pull cart for taking it to the police station. Full stop. PW8 was a signatory to the inquest report, comma, EXT 4, and he identified his signature therein as EXT 4 Roman 4. Full stop. PW8 further stated that the appellant was found sitting in the paddy field. First, during cross-examination, command PW8 stated that he signed the inquest at the field itself, but he did not know why his signature was taken. First. It is evident. Before dwelling on the testimony of PW2, PW3, PW6, and CW2, it appears appropriate to mention about the relationship existing between them. First, PW6. was an elder brother of the deceased. And CW two. Full stop. The appellant is the husband of CW two. Full stop. PW three is a son of PW six. And PW two is the wife of PW three. Full stop. CW one, meaning thereby comma, CW one is an aunt of PW three and the sister-in-law of PW six. Sister-in-law or sister? Okay, okay, okay. Full stop, okay, full stop.
Relationship with the applicant.
Huh?
Relationship with the applicant.
No, PW three. PW three is
That you have already, that has been included.
the appellant is an uncle-in-law of PW three.
PW two.
Huh?
PW two,
PW two.
uncle in law, if it is law, PW two. Or simply it can be said,
She is Pehi. Pehi is Peha.
yeah,
No, 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 no.
but appellant's relation with,
Not required, connected already. I've said so much.
but appellant's relation with any of those is also enough. That the appellant,
Not required, I have mentioned what are the relations.
Right.
Why so many
Right.
elucidation is required.
Right.
I have said. Better. In her evidence in chief, PW two stated that the appellants, the house of the appellants was near to their house. Close to. The deceased was her uncle-in-law. Close to. On the date of the incident, that is, in the evening of Bhadra, she was in the backside of her house drying clothes. So then, she saw the appellant inflicting 4-5 blows by a dog on the deceased and kill him. And thereby killing him also. The deceased had gone to the paddy field to bring his cows, and it was at that time, the appellant inflicted the dog blows on him. PW two testified that she then rushed to save her uncle-in-law, that is the deceased, but the appellant saves her. She stated that there were no other persons near the place of occurrence at that time. Out of fear, she got fainted. PW two further stated that the deceased died of the injuries police person came thereafter and interrogated her. First of, she further stated that her statement was recorded before the court and she had exhibited her previous statement as EXT2 and identified her signatures therein. First of, software. During her cross-examination, PW2 stated that the deceased was her uncle-in-law. Full stop. Sorry, the appellant was her uncle. Full stop. The appellant was a bachelor and used to stay in the residence of the appellant as domestic helper for a long time. The deceased was a bachelor and he used to stay in the residence of the appellant as a domestic helper. Full stop. The appellant had his wife and his daughter had already got married. Full stop. She did not have the knowledge about the reason why the deceased left the house of the appellant. She had no knowledge of any quarrel between the appellant and the deceased for leaving the house. Full stop. PW who further stated that while going to bring back the cows, the deceased had one lathi in her hand, in his hands, and there was no dao in his hand. Full stop. She did not see any quarrel between the appellant and the deceased at the place of occurrence. Full stop. She denied the suggestion that at the time of giving statement, denied the suggestion that she did not. The time of giving statement to police, she had stated about some quarrel between the accused and the appellant. So she denied the suggestion that after the quarrel, the deceased tried to assault the appellant with the lathi. And they used to take the service from the deceased. And for the same reason, there was a quarrel between them and the deceased. She also denied the suggestion that to grab the property of the appellant, her husband, PW3, had concocted a false case to keep the appellant in jail. PW3 in his evidence in chief deposed that on the date of the incident, he saw gathering of some people when he returned, when he was returning home, first of, as the persons were found watching something. The persons were found watching something. First of, then his aunt, CW1, told him that the appellant had killed the deceased, and for that reason, he should not go to the place of occurrence. However, he had gone to the place of occurrence, that is the petty field, in front of the house of the deceased, and going there, he saw the dead body of the deceased lying there with injuries on his person. Full stop. PWC further stated that he saw the apple there with a cow. He saw the apple. They are crying with a cow in his hand. Full stop. The persons gathered there want PW3 to leave the place. Then, PW3 rushed to Obhoyapuri police outpost to inform the matter to the in charge. Very post. PW3 stated that his wife, PW2, kept herself concealed. Full stop. Police personnel came thereafter with him and apprehended the appellant from his house. Full stop. Police also seized one now from the appellant. By seizure list, ext3, wherein he gave his signature as ext3 1. Full stop. PW3 also identified the now, seized by exhibit ext3 seizure list, as mat ext1. Full stop. The PW3 also exhibited the inquest report ext4 and his previous statement recorded before court as ext5 and his signatures therein. During cross-examination, PW3 stated that he did not see the incident of killing the deceased. It was CW1 2 who told him about the incident as she has seen the incident. PW3 further stated that he used to reside with the deceased at his residence and the house was built by the deceased. He denied a suggestion that the house was built by the appellant and they had forcibly occupied the house. Also, he denied to have any knowledge that for occupying the house, there was quarrel between the appellant and the deceased. Also, he further denied a suggestion that for keeping him in the house, on the date of incident, the deceased objected to. Sorry, the appellant objected to. Appellant made his objection to the deceased, and the deceased assaulted the appellant with a stick. He also denied a suggestion that at the time of the incident, he had also attempted to assault the appellant. PW6 in his examination in chief, reports that on 20/09/2015, his sister, CW2, who was the wife of the appellant, came to his house and informed him that the appellant had killed their brother, that is the deceased. On being so informed, he went to the place of occurrence, that is the hill in front of the house of the appellant and the deceased, and saw the dead body of the deceased packed in packed home. By the time, the police personnel had arrived at the PO, First off, PwC stated to have lodged the FIR, EXT5, and he identified his signature therein as EXT51. First off, on arrival at the place of occurrence, PO, PW6 was told by PW3 and PW2 that the appellant had killed the disease by cutting Ujada. In his cross-examination, PW6 stated that he did not see the incident of killing the diseased, as he was at his workplace at that time. PW3 stated that his house was at a distance of about 1 mile from the PO. Reiterating that the disease was a bachelor, PW6 stated that the appellant and the disease used to reside together earlier. Thereafter, his son, PW3, and his daughter-in-law, PW2, started residing together in the house of the deceased. First of PW6 further stated that the houses of the appellant and the deceased were contiguous, were adjacent to each other. And at the time of incident, CW2 was with the deceased. First of PW6 further stated that CW2 might have seen the incident, and it was CW2 who had informed him about the incident. And the same, and accordingly, he reported the matter to the police station. PW6 further stated that PW2 and PW3 were looking after the property. He denied a suggestion that to occupy the land and house built by his son, PW3, the deceased made an attempt and they disturbed the appellant. From the testimony of his CW1 was attached to Safri outpost as an assistant sub-inspector of police. When he was summoned to depose as CW1 on 18/7/2017, CW1 exhibited the general entry, the general diary entry was general diary entry number 287 dated 20/09/2015 as EXT capital X within brackets Roman two. Along with the general diary entry book as EXT capital X. Full stop. CW1 further deposed that the general diary entry number 287 was registered on 20/09/2015. And in the same entry, comma, it was mentioned that at about 4 p.m., comma, BW3 came to the police outpost to verbally inform them the appellant had killed the deceased with a dao. Full stop. Father, my- On analysis of from the testimony of the witnesses, comma, PW2, PW3, and PW6. It is discernible that it was only PW2 who had claimed to be the eyewitness to the incident. The PW2, from the testimony of PW2, comma, sorry, 3. From his testimony, comma, itself, comma, PW3, in his testimony, comma, PW3 came to be a post-occurrence witness. Like PW6. Post- Both statements of both PW2 and PW3 were recorded earlier under section 164 of CRPC. Post- PW exhibit 2 exhibited her previous statement as EXT 52 and PW3 exhibited his previous statement as EXT 54.
Page 60. No, sorry, 5.
5. The learned amicus curiae has submitted that these two witnesses, PW2 and PW3, had projected a different version in their previous statements.
Case number 2.
Okay. On perusal, it is found that neither PW two nor PW three was specifically confronted by the defense when they were cross-examined. By making specific reference to their previous statements, EXT two and EXT five. Unlike the statements recorded under 164 CRPC, which can be used only for the purpose of contradiction, statements recorded under section 164 CRPC can be used for both contradiction and corroboration. Full stop. A statement when a witness is to be confronted with his stroke her previous statement for the purpose of contradiction, the statement as such is required to be put to the witness. And if the witness denies having given such statement, it does not amount to admission. And if it is proved that he had given such statement, the attention of the witness must be drawn to that statement. Close stop. Section 145 of the Evidence Act is clear on this aspect. Close stop. The object is to give the witness a chance of explaining the discrepancy or inconsistency and to clear up a particular point of ambiguity or dispute. Full stop. In the instant case, exhibit EXT2 and EXT5 were not put to the witnesses, PW2 and PW3 respectively, nor these witnesses were given any opportunity to explain it. Full stop. Therefore, the previous statements, EXT2 and EXT5, even if they are assumed to be their previous statements, those are of no assistance to the appellant regarding these witnesses giving a different person in their previous statements. Para 21.1. PW3, in his testimony, stated that it was CW2, his aunt, who informed him about the assault made on the deceased by the applicant, her husband. In a similar vein, BW6 also deposed to the effect that the effect that on 2009, his sister, with CW2, came to his house and informed him that the appellant had killed the appellant, bracket, her husband, killed their brother, that is the appellant. First. And the deceased, who was a brother of both CW6 and CW2. So, R6 page. In the source it, an EXC7, CW2 was not cited in the list of prosecution witnesses by the IO. The learned trial court after going through the case records, have after closure of evidence from the prosecution side. On 26, 2000. Comma, examination of the appellant under section 313 CRPC 1, 2002. And after going through the case record, comma, had reached an opinion on 27/2/2018 that CW2 would be a necessary evidence, witness. First of the Online Trial Court and thereafter issued summons for the purpose of examining CW2, invoking the power under section 311, CRPC. First. CW2. When examined by the court, deposed that the appellant was her husband and the deceased was her younger brother. Full stop. On the date of the incident, comma, she was at her matrimonial house at Rongpothar Gaon. Full stop. On that day, so she stated that on that day, comma, seeing a gathering at the field and learning that her husband, in fact, the appellant, had killed and learned that her husband, the appellant, killed her brother, the deceased. So after some time, police personnel arrived with the PO and she deposed that she saw cut injury marks on the neck of the deceased. When cross-examined by the prosecution, 2014-2018 order 6. Comma, CW2 stated that she had seen the incident of cutting her brother, in fact, the deceased, by the accused, by the appellant, within bracket, her husband, on her own. CW2 was thereafter cross-examined by the defense. EW2 stated that the deceased used to stay in their residence, in the residence of the appellant. First of. Subsequently, PW3, PW3 with his wife, PW2 started living with the deceased. And therefore, the deceased left their house. The house was constructed by the deceased. But the PW3 later on possibly possessed the house of the deceased. On this point, on this issue, PW3 had a quarrel. Sorry, the deceased had a quarrel with PW2 and PW3. First of, CW2 further stated that in her matrimonial home, she used to live with her husband, but it is the appellant, and their daughters were already married. First, after the incident, police found her husband at their residence. First, CW2, during her prosecution, further stated that she did not state, she did not tell PW3 that the apple had cut the disease. First of, para. So, PW3 in his testimony stated that it was CW who had informed him that the appellant had killed the disease, CW2, during cross-examination, stated that she did not tell PW3 that the appellant had killed the disease. Also, that part of the testimony of PW3 that he was informed by CW that the appellant had killed the disease is has first of. The defense had, however, did not cross-examine CW2 as to whether CW2 had gone to the house of PW6 and informed him that the appellant had killed the disease. Full stop. PW6 stated that on being informed by CW2, he had lodged the FIR, EXT. So it's what I see. in Balram Gopal Patel was the state of the art. Rohan. Else. Observe that. Testimony of a witness. Based on the information of another person. Is invisible in evidence. If the informant is also examined in the case. The our court has observed that observed in the following manner. There is an Dr. Weaver. Turning back to the facts of the case, we find that it was the information given by CW to PW6, which prompted PW6 to lodge the FIR on that day itself. First of all, the fact that CW2 had informed PW6 about the incident of assault was not put to cross-examination by the defense when CW2 was examined. First of all, does come up. That part of the evidence of PW6 that he had lodged the FIR on the basis of information received from CW2 would not be hit by the rule of exclusion of hearsay evidence. Is at the same time, is to be kept in mind. That part of the information. When CW stated that was that still remains the real. Justice Bahar Islam has Supreme Court has in a Supreme Court judgment, Justice Bahar Islam has said so. Thereafter it is approved. So that part is spectrum of giving the information, which prompted the CW3-6 laws. That part is admissible. Not the regarding truth of that he has killed that. only that about giving the information, influencing PW6 to lodge the appeal. That part. Fair enough. The law relating to section 311 CRS has been explained in a by the Honorable Supreme Court in a recent judgment AP Tamil Mara versus the state by Deputy Superintendent of Police 2025 INSC 576. It is acknowledged that there is a wide discussion with the courts under section 311 CRS. These powers can be exercised so moto also. Also, as the object behind such sumoto power is that the court must not be deprived of the benefit of any valuable evidence. It is absolutely necessary that court must be apprised of the best evidence available. The courts have therefore wide powers to decide on their own. A witness is required to be called under section 311 CRPC. And the power under section 311 CRPC can be invoked at any stage of a trial, even after the closing of evidence. Section 311 CRPC can also be read along with section 165 of the Evidence Act. As the powers of the court under section 165 of the Evidence Act are complemented to section 311 CRPC. Full stop. If the court finds that a person should have been examined as a prosecution witness, or she was omitted from the list of witnesses due to some oversight, mistake, or for any other reason, the court may examine such person by summoning him as a court witness. When the court calls a person as a court witness, there are some restrictions regarding cross-examination of such witness. In a case, neither party is interested in examining a person as a witness, yet the court feels that the evidence of such a person is necessary for a just decision, the court, though cannot compel either the prosecution or the defense to call a witness, but it can invoke its power under section 311 CRPC, read with section 165 of the Evidence Act, and call such a person as a court witness. Full stop. Court witnesses can be cross-examined by either side, but only with the leave of the court. Further, the cross-examination is to be restricted only to what was stated by this witness in his stroke her reply to the questions of the court, and the court witness, and a court witness cannot be contradicted to his stroke her previous statements made before the police. There is a statements under section 161 CRPC. Returning back to the testimony of PW2. We do not see that the defense had put any question or had confronted her by putting any question to PW2 that it was impossible for her to witness the incident of assault on the deceased by the appellant from the place, that is, from the place where from she had witnessed the incident. So according to PW2, at the relevant point of time, she was in the backside of her house. So stop. Though learned Amicus Curie has placed reliance in the sketchmate of the PO EXT,
6.
to urge the point,
And also
comma,
PW3. This is the place of incident.
no, we are on that direct evidence. We are on direct evidence.
On the direct evidence only.
PW2 has to be put.
PW3 has.
No, we are not going to PW3.
PW3 not 164. On in GPSC,
No, direct evidence. Did you put anything? No, we are on that only. Why you are disturbing my flow? No, yes. It's line to go lane, no, pura item like line to go. That's the point. Comma. In absence of any confrontation by the defense, any confrontation on such points, confrontation with PW on that point by the defense during her testimony. The same cannot be urged at the appellate stage. In the absence of any foundation. Full stop. In any view of the matter, comma, is the testimony of the witness before the court, which has the sanctity. Full stop. A sketch map of the place of occurrence is not a substantive piece of evidence. Full stop. Para. There's it is settled that a conviction can be based on the sole testimony of a solitary witness. Full stop. But in order to make the testimony of a solitary eyewitness the basis of conviction, comma, one of the prerequisites is that his or her presence at the place of occurrence has to be natural. Because insofar as we witnessing the incident of assault on the disease by the append is concerned, comma, PW2, her house being at a close vicinity to the place of occurrence, comma, is to be treated as a her presence at the relevant time in her own house is to be treated. It cannot be doubted, and is to be treated as nature. Full stop. The another prerequisite to make the testimony of solitary eyewitness the basis of conviction is that the testimony of such eyewitness should be strong, reliable, and free from any blemish. Full stop. Where is citation?
Case number,
No, any citation you have, name the case. Also. It is also a settled proposition that it is the quality of evidence, not the quantity of evidence which is material. Full stop. It has been settled that the evidence of a single witness may sustain his sentence, whereas a host of vulnerable witnesses may fail to support a simple charge. Full stop. Yes, what is the citation?
1996, one SCC,
1996.
one SCC, 614. Kartik Malbar,
1996,
614,
1996,
one,
one SSC,
para 11.
61,
Four. Here got page number 246 and
it has been held in Kartik Malhar versus State of Bihar. 1986, one SSC. Check this out. To the effect that the case of the prosecution cannot be discarded merely on the ground that it was sought to be proved by only one eyewitness, nor can it be insisted that the corroboration of the statement of that witness was necessary by other eyewitness. Full stop. It is open to the court to record a conviction on the basis of the statement of a single witness, provided the evidence of that witness is reliable, unshaken, and consistent with the case of the prosecution. You did not confront her with the previous statement. Full stop. Having considered the testimony of PW two from all standpoints, our testimony is found to be strong, reliable, and due to failure on the part of the defense to answer her testimony, her testimony is found to be without any blemish. Full stop. As full stop, it is it has it is relevant to note that CW2, when she was cross-examined by the prosecution with the leave of the court, had admitted about witnessing the incident of assault on the ladies by the appellant on the date of the incident. It is pertinent to state that the house of CW2 was also adjacent to the house of PW2 and to the place of offense. Full stop. Para. The medical evidence adduced by the autopsy doctor, sorry, PW2 had also deposed PW in her testimony, PW2 stated that the appellant inflicted 4-5 blows on the diseased by now. By now. This ocular testing, the ocular testimony with regard to the assault is found to be consistent with the medical evidence adduced by the prosecution through the autopsy Dr. PW1 and the postmortem examination report EXT. From the testimony of PW1 and the PME report EXT so and so. In the testimony and postmortem. It was recorded that the disease sustained 5 number of injuries, as mentioned herein above, on his person. And out of those 5 injuries, 4 of them were sufficient to cause his death. Those are absolutely consistent. The autopsy doctor, Dr. PW1, in his testimony, further mentioned that those injuries might be caused by using a sharp cutting weapon like dao. Full stop. Therefore, the ocular testimony of PW3-2 is found to be consistent with the medical evidence. Artisan, 1 second, so and so. Anything left? For the in the light of the discussions made above, discussion and the observations made above, and for the regions assigned hearing, we are not persuaded to arrive at a view, as asked by the learned Amicus School, that the evidence is deficient to sustain a conviction. On the other hand, we find that the prosecution has been able to lead evidence to bring home the guilt of murder against the appellant beyond all reasonable doubt. Consequently, the criminal appeal is found to be bereft of merits. As a result, it fails. Microscope record completely. Anything left? Maybe if I have omitted something, I'll fill up. It's difficult to keep track. But
The lordship was saying that I interrupted in between.
no.
The lordship was saying that I tried to project a case by showing the sketch map that she couldn't have seen the incident. Now, PW3 has also stated that the incident took place in front of their house. So from that also an analogy can be taken that she was at the back.
I'll hear about PW.
She was at the
Then
backside.
You
The
make
incident
my
was-
thing, because these are all pausas, huts. Backside is not a multi-story building. Like, like Reliance Mall, right? It is small hut, backside in a triangular diagonal shape. It is not
It
as
can
per
be.
your sketch map. Then I have to criticize more.
Exactly.
Only two houses,
Two
open
fields.
field
Open.
and diagonal, triangular shape. That is why I did not bother to actually, I have seen it. It is in triangular shape. At 3 points, it can be seen from, and
Can be seen.
these houses are only two guest house. Backside means open back house,
Open.
not like 3 feet by rear, front 3 feet in a metro, side 3 feet, left and right. It's not that. Small house, big field, open. See? You should have confronted PW2. Had their previous statements been brought, the case would have been different. Yes, Mr. Bhattacharya.
Item number 10.
At this stage, we don't have.
My lord, maybe date 3rd of June. my lord.
Huh?
3rd of June. For last 10 years, he is without any wife.
In the 3rd of June, we have fixed many matters. It's
Then,
very easy.
Don't fit, my lord.
Some-
Sixth, my
Sometime
lord,
later,
let's,
the week commencing from 9th.
nine, sixth,
You put it,
sixth,
week commencing from 9th,
then 10th.
10. 10.
Like,
Okay, Bhattacharya, appellant. Miss
For amendments.
B. Wing, senior counsel, appearing as amicus curiae, are present. For the respondent. Present. As supervisor. Is the case on?
10.
Yes, Mr. You have any other case?
Next one is.
Yes, conviction or acquittal? Huh?
when, confession statement is also.
How, for how long he is in jail?
Uh,
As
the
per
case is
cause
of
list?
1994.
Huh?
The cases of 1994.
As per cause list, how long he is in jail?
It is 7 years and I have calculated from the period he was in
Hmm.
bail. It is 8 years.
Then it needs some expeditious consideration.
He is in jail for 8 years, 3 months, 6 months.
Okay. Let's put it on someone else's step. 8 years. Okay, B. Prasad and Amicus Curiae, Mr. Gautam. Huh? Kaushik. Planet additional public prosecutor for correspondence are present and hence I will be the shop for the party. Silent Kumar, there are forms. Non-miscellaneous they were you. Huh? No, non-miscellaneous they did it. Say fourth or fourth. We'll try. We'll start if possible. If we hear it for half an hour, 45 minutes, we keep it part and post it on the next. How many witnesses?
6.
Okay.